Hello, my name is Alessandro Cupido Carlarosi, and I'm from Regis High School.
My name's Andrew Mazzuti, and I'm also from Regis High School.
And today we're going to be answering questions regarding the Ken Paxton v. Free Speech Coalition case.
What, if any, is the value of low-level speech such as pornography?
Well, we'd say that low-level speech such as pornography has very minimal social value and poses significant harm to children. Unlike political or educational speech, which is protected under the First Amendment, it doesn't actually contribute meaningfully to actual public discourse or civic engagement. Instead, it normalizes harmful behavior, exploits vulnerable populations like children, and exposes minors to explicit material that can negatively impact their development. While the First Amendment protects most forms of speech, such as political or educational speech mentioned before, it was never intended to actually shield content that degrades community standards or endangers children. Protecting children from the dangers of online pornography is a very compelling state interest, and laws requiring age verification are a necessary and reasonable step to actually achieve that goal.
Was the First Amendment created to protect this kind of speech? Does that matter here?
But while the First Amendment protects most forms of speech, it was never actually intended to shield content that degrades community standards or endangers children and minors. Courts recognize that the main reason for the creation of the First Amendment is the protection of religious, civic discourse, and political speech. Pornography is not in this category. This is very important and matters specifically to this case because since pornography was not the intended type of speech the First Amendment was designed to protect, its regulation should face less constitutional scrutiny. The state's interest in protecting children from harmful material could outweigh the minimal and expressive value of pornography.
Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
So we'd say that minors' rights are rightfully limited because courts have consistently ruled that children don't have the same right to access harmful content like adults, seen in the case of Ginsburg versus New York. But we'd say that adults are minimally impacted because they still have access to any and all websites per the age verification, but they still have to complete an age verification. However, the rights aren't impacted to a way to violate the First Amendment, as we don't see the same happening for gambling websites and etc. On the other hand, the rights of platforms are affected because they must verify users' ages, but this is seen as a content neutral regulation of actual business operations and not speech. The law doesn't ban any speech, but only ensures that adults, not minors, can access certain online content. Courts have upheld similar regulations on television, tobacco sales, and zoning for adult businesses. Therefore, the First Amendment rights of these groups are burdened but not violating, as a law in previous cases serve as a compelling government interest in actually protecting these children.
Why can the government simply ban access to pornography online?
Well, the government can't impose a total ban of pornography because of the First Amendment's broad protections. But that doesn't mean that it's not a powerless act. While the Constitution protects most forms of speech, it was actually never intended to provide absolute protection for content that harms society, especially minors. The Supreme Court has ruled in the past that obscenity is not thus protected speech, and the state's interest in protecting children from harmful material is a compelling one, which nevertheless proves its importance despite some precedent. And rather than a total ban, the government can require age verification measures to ensure that children don't access the explicit material. Unlike a blanket ban, House Bill 1811 is narrowly tailored to target access for minors while still allowing adults to access the legal content. If protecting children from explicit material is truly a shared priority, then the common sense restrictions, like age verification, should be seen as both constitutional and necessary in this case.
In what ways is the Texas law a content-based imposition on speech? In what ways is it not?
The main thing is here that House Bill 1181 protects minors, not regulates speech. The primary goal of the bill is to actually protect minors from the documented harms of pornography, which is a recognized compelling state interest. This law doesn't suppress or ban speech, but instead regulates access to content that's very inappropriate for children. Age verification systems are put into place and are a reasonable and narrowly tailored means to actually achieve that goal without infringing or impeding on adults' rights to actually access legal material. This legislation is not about targeting specific viewpoints or ideas which are protected under the First Amendment. It's actually about ensuring that children are shielded from materials that could harm their development. Courts have long recognized the state's actual authority to regulate access to obscene or harmful material for minors. House Bill 1181 is consistent with that tradition. Courts have upheld laws aimed at protecting minors from that harmful content and recognizes the state's authority to act in the interest of public health and safety. The bill stands firmly on this legal foundation and is crafted to withstand constitutional scrutiny.
Is including social media and search engines under the age verification requirement a reason to find this law unconstitutional?
Well, social media and search engines can facilitate access to harmful content because social media platforms and search engines actually play a significant role in the distribution and accessibility of adult content, including to minors. By including these platforms under House Bill 1181's scope, the law actually seeks to ensure that minors cannot easily stumble upon or be directed to the sexually explicit material. This provision is directly tied to the state's compelling interest in protecting children from harm. The U.S. Supreme Court has acknowledged in the past that the internet is not an unregulated space and does not have reasonable measures to protect minors. As such, an Ashcroft v. ACLU can be constitutional, but extending age verification requirements to search engines and social media ensures the effectiveness of the law and prevents loopholes that could otherwise undermine its intent. The inclusion of search engines and social media is not an overreach. These platforms often display explicit content or links to it, which minors can access with ease. By extending the requirements to these entities, House Bill 1181 ensures that a comprehensive approach that addresses all avenues by which minors could access harmful material. Courts have upheld similar protective measures when appropriately justified and tailored, as in the case of House Bill 1181.
The law requires age verification when more than a third of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
Well, if the threshold for requiring age verification were actually increased, the law would most undoubtedly impose fewer obligations on websites, but would also weaken its effectiveness in actually protecting these children that we talk about. Websites with a substantial amount of harmful content, yet falling below the higher threshold, could avoid regulation, which would leave minors exposed to inappropriate material and obscene material. The current one-third threshold strikes a somewhat reasonable balance and ensures that platforms with actual significant adult content are held accountable without unnecessarily burdening websites that primarily provide family-friendly material. Our priority remains in safeguarding children while also ensuring fairness in implementation.
Ashcroft versus ACLU applied strict scrutiny to the law that burdened adults' access to online speech, not the rational basis test. Why should the court not apply the same standard here?
Well, the government has, over the years, shown that it has a legitimate interest in protecting children from pornography and other types of explicit content. And the law in this case, seen as in House Bill 1181, is actually narrowly tailored. The law doesn't ban adults' access to the obscene content. Instead, it places a narrow, focused obligation on platforms to verify age only for those attempting to access content that would be harmful to minors. Unlike COPA, which applied to an entire category of commercial websites, this law only targets specific categories of harmful content and does not require general age verification for all users, Many websites have already required age verification, for example, some alcohol or gambling websites, and users can easily verify their age with tools such as single sign-on systems.
Ashcroft versus ACLU identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
No, filtering settings have not proven to be an effective alternative for protecting minors online. While filters have somewhat improved since Ashcroft versus ACLU, they're still very easily bypassed by tech-savvy minors using VPNs, proxy servers, or private browsers. Filters also rely on AI-based detection, which is often overbroad and blocks educational or health-related content, or actually under-inclusive itself while failing to block harmful material. Unlike in 2004, today's internet is driven by user-generated content on platforms like social media, which changes constantly and can't actually be filtered in real time. Relying on parents to actually install and manage filters is very unreliable and extremely unrealistic, especially in households where parents lack technical skills or resources. The Texas age verification law shifts the burden to these platforms rather than these parents, which are in a better position to control access. Given the modern internet landscape, filtering is no longer a viable solution, and age verification is now the least restrictive and most effective and hands-off means to protect children from harmful content.
If the court were to find that the Texas law burdens the First Amendment rights of adults, does that mean petitioners win?
Well, no, as finding that the Texas law burdens adults' First Amendment rights does not automatically mean that the petitions win. The key question is whether the burden is justified under constitutional standards. Courts apply the strict scrutiny test if the law is seen as content-based restriction, requiring the state to prove that the law serves a compelling government interest and is narrowly tailored to achieve that interest using the least restrictive means. However, if the court finds that the law is content neutral, thus regulating access and not speech, as in the very case that we see with House Bill 1181, a lower standard of review, like intermediate scrutiny or rational basis scrutiny, may apply.
Adults concerned for their privacy may not access websites requiring age verification. Is that a sufficient reason for striking this law down?
Well, while some adults might be somewhat apprehensive about privacy while accessing websites requiring age verification, this concern alone is not an actual sufficient reason to strike down this law. Protecting minors from harmful material is a very compelling state interest, and age verification is a reasonable, narrowly tailored method that achieves that goal without impeding on people's privacy. Many verification systems allow privacy-conscious options, such as third-party verification systems, which actually protect user anonymity while actually ensuring compliance as well. The law doesn't prohibit adults from accessing legal content. It actually just simply ensures that such access doesn't come at the expense of exposing these minors to inappropriate material. The balance struck by House Bill 1181 respects both privacy concerns through the third-party verification services and the state's duty to actually protect these children.
If the court finds that the law requires examination under strict scrutiny, does that mean that the petitioners win?
If the court applies strict scrutiny to House Bill 1181, it does not mean that petitioners automatically win in this case again. Strict scrutiny requires the state to demonstrate that the law serves a compelling interest and is narrowly tailored to achieve that interest. Protecting minors from harmful and inappropriate content is undeniably a compelling interest. The age verification requirements of this law are carefully designed to address that issue without unnecessarily restricting lawful speech or access to the adults. We're confident that House Bill 1181 can withstand the strict scrutiny because it strikes the right balance between protecting children and respecting the constitutional rights that we see are protected by the First Amendment.
Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in a traditional brick-and-mortar store?
Well, while there are some similarities between the privacy concerns of online age verification and those in brick and mortar stores, the contexts are very fundamentally different. In physical stores, age restricted purchases often require showing an ID briefly without creating a lasting record. Online, however, that verification system may involve submitting personal information that could be stored, which somewhat raises additional privacy concerns. But with that being said, modern age verification systems actually address these issues by using secure third-party systems that we've mentioned before that protect anonymity while also ensuring compliance. The key difference is that online spaces, unlike actual physical stores, can be accessed instantly and anonymously, which makes robust verification measures actually essential to protecting these minors. These privacy concerns are valid, but also manageable as well, and they don't outweigh the state's compelling interest in shielding children from harmful material.
In the years since Ginsburg versus New York, have increased technology capacities increased or decreased the privacy concerns associated with age verification processes?
Well, since Ginsburg v. New York, technological advancements have certainly increased both the capabilities and complexities of age verification. On one hand, the ability to verify online age verification has greatly improved, and that allows for more secure and accurate methods without requiring individuals to actually share sensitive and personal information. And third-party services and advanced technologies can now verify age without compromising privacy, often using minimal data and ensuring that the user's personal details are not stored nor exposed. But on the other hand, the increased technological capabilities of today's internet mean that personal data can be more easily collected, stored, and potentially misused. This raises legitimate privacy concerns, but these concerns can be mitigated by using secure, anonymized age verification systems that limit the amount of data collected by these websites. While the risk to privacy has increased with new technologies, proper safeguards can and will be put in place to ensure that age verification processes don't infringe on an individual's right to privacy. The key is balancing these concerns with the need to protect minors from the harmful content, which remains, as we stated, a compelling government interest.
Online access to harmful materials presents unique obstacles to parents trying to protect their kids. If this law is found to be unconstitutional, what else can Texas do to protect minors accessing online material?
Well, if the law were to be found unconstitutional, Texas would still have other avenues to protect minors from this harmful online material. For one, we could pursue the development and implementation of more robust educational programs aimed at both parents and children, teaching them about the risks of online content and importance of online safety. Additionally, the state could support or incentivize the use of parental control software and other age restriction tools which already exist and are commonly used by families to manage what minors could access online. Texas could also work with tech companies to encourage or mandate better content moderation practices, particularly on social media and websites that host user-generated content. Another option could be the expansion of laws targeting explicit content distributors, requiring them to employ stronger safeguards such as enhanced content labeling or mandatory disclosures about the nature of their material. Ultimately, while this law might face challenges, the state is committed to finding the legal and practical ways to protect children online, ensuring that we balance constitutional rights with our own duty to shield minors from harm. Thank you.